168 pages. That's how long Judge McGlynn's ruling striking down Illinois gun ban is. And everyone, the media, politicians, gun rights groups, they're all focused on the same quotes. The self-defense argument, the commonly owned weapons language, the comparison to airbags and lifeboats, but buried in those 168 pages is one line that nobody is talking about. One sentence that should terrify every American, whether you own guns or not, because this line isn't just about the Second Amendment. It's about something much bigger, much more dangerous. And when I show you this quote, you're going to understand why the mainstream media is avoiding it like the plague. Because it exposes exactly what's happening to your constitutional rights in America today. Stay with me. This is bigger than guns. This is about the future of freedom itself. Hey everyone, your name, and before we dive into this, I need you to do something. Hit that subscribe button right now, because what I'm about to show you is exactly the kind of content that YouTube's algorithm doesn't want you to see. This isn't a rant. This isn't conspiracy theory. This is a direct quote from a federal judge's 168-page ruling, word for word. And I'm going to explain why this one line matters more than anything else in that entire document. Let's start with some background. And then I'm going to show you the quote that changes everything. On November 8th, 2024, U.S. District Judge Stephen McGlynn struck down Illinois assault weapons ban in a massive ruling. The Protect Illinois Communities Act passed after the tragic Highland Park shooting in 2022 banned AR-15s, similar rifles, and magazines over certain capacities. Judge McGlynn said the ban was unconstitutional. He ruled that AR-15s and similar firearms are commonly owned by Americans and used for lawful purposes like self-defense. He compared firearms to safety equipment like airbags, lifeboats, and storm shelters. The media covered this. Gun rights groups celebrated. Politicians on both sides reacted. Governor Pritzker vowed to appeal. Attorney General Raoul filed his appeal the same day. Everyone focused on these parts of the ruling. Quote 1. What is particularly disturbing is that the prohibition of weapons that are commonly owned and used by citizens are now banned, depriving citizens of a principal means to defend themselves and their property. That's a powerful quote. Gun owners love it. It's been shared thousands of times. Quote 2. The government may not deprive law-abiding citizens of their guaranteed right to self-defense as a means of offense. Another great line. Clear. Direct. Constitutional. These quotes are important. They matter. But they're not the line. They're not the quote that reveals what's really happening in America. Let me show you what everyone is missing. Here it is. Page after page into Judge McGlynn's ruling, he writes this. Sadly, there are those who seek to usher in a sort of post-Constitution era where the citizens' individual rights are only as important as they are convenient to a ruling class. Read that again, slowly. A post-Constitution era. Not interpreting the Constitution differently. Not balancing rights with safety. A post-Constitution era, as in after the Constitution. Beyond the Constitution, where the Constitution doesn't matter anymore. And who's pushing for this? A ruling class that only cares about your rights when they're convenient. On screen, host pauses, lets that sink in. This is a federal judge saying this. Not a politician. Not a commentator. Not me. A judge who spent months hearing evidence, reading briefs, and analyzing the law. And he's telling you, in plain English, that there are people in power who want to move beyond the Constitution, who see your rights, not just the Second Amendment, as obstacles to be removed when they become inconvenient. Let me break down why this line is so explosive. Post-Constitution era isn't about updating the Constitution or amending it through the proper legal process. That's how our system is supposed to work. If you want to change the Constitution, there's a process. Propose an amendment. Get 2/3 of Congress to approve it. Get 3/4 of states to ratify it. That's hard. It's supposed to be hard. Because the Constitution protects fundamental rights that shouldn't change based on whoever's in power. But a post-Constitution era is different. It means ignoring the Constitution entirely. It means treating constitutional rights as suggestions rather than guarantees. It means saying, yes, the Constitution says this, but we're going to ignore it for the greater good. Judge McGlynn is warning that this is already happening, not in the future. Now, look at what he says next in the ruling. The oft-quoted phrase that no right is absolute does not mean that fundamental rights precariously subsist subject to the whims, caprice, or appetite of government officials or judges. You've heard that phrase before, right? No right is absolute. Politicians love saying that. The First Amendment isn't absolute. The Second Amendment isn't absolute. And Judge McGlynn is calling them out. He's saying, yes, there are limits to rights. But those limits can't be based on the whims or appetite of whoever happens to be in power. The problem is that no right is absolute has become code for we can restrict your rights whenever we want. Don't like what people are saying? Well, the First Amendment isn't absolute. Don't like what people are owning? Well, the Second Amendment isn't absolute. Judge McGlynn sees where this is going. A post-Constitution era where rights exist only when they're convenient to a ruling class. Now, let's talk about that second part of the quote, ruling class. That's a loaded term. It's not language judges typically use, but McGlynn chose it deliberately. Who is he talking about? He's not just talking about politicians. He's talking about an entire class of people who believe they know better than you. People who think that because they have power, education, or influence, they should make decisions for everyone else. This includes politicians who pass laws restricting your rights for your own good. Bureaucrats who create regulations without going through Congress. Tech companies who decide what speech is misinformation. Corporate media that tells you what to think. Judges who ignore the Constitution and rule based on their personal beliefs. These aren't conspiracy theories. These are observable patterns. We've seen it with COVID lockdowns. We've seen it with censorship on social media. We've seen it with gun control laws that exempt the wealthy and politically connected. The ruling class doesn't trust you to make your own decisions. They don't trust you to own firearms responsibly. They don't trust you to speak freely without fact checkers. They don't trust you to raise your kids, run your business, or live your life without their oversight. And Judge McGlynn is saying, this mindset is fundamentally un-American. It's anti-constitutional. And it's dangerous. Let me give you concrete examples of this post-Constitution era in action. Example 1. Gun control exemptions. Illinois gun ban had exemptions. Retired police officers could keep their AR-15s. Private security for wealthy politicians could carry them. But ordinary citizens? You're too dangerous. That's ruling class thinking. The elites get protection. You don't. Example 2. Selective enforcement. Multiple Illinois county sheriffs refused to enforce the gun ban. They said it was unconstitutional and they wouldn't arrest law-abiding citizens. The Illinois Sheriff's Association even filed a brief supporting the lawsuit against the ban, but the state government demanded enforcement anyway. Your rights are inconvenient to their agenda. Example 3. The Appeal. Illinois. Attorney General Kwame Raoul filed an appeal the same day Judge McGlynn issued his ruling. Not a week later. Not after reviewing the decision. The same day, they didn't care about the 168 pages of legal reasoning. They didn't care about the constitutional analysis. The ruling was inconvenient, so they immediately tried to overturn it. That's exactly what Judge McGlynn is warning about. So why isn't anyone talking about this post-Constitution era quote? Simple, because it's too accurate. It exposes too much. If the media covers this quote, they have to explain what a post-Constitution era means. They have to acknowledge that powerful people want to move beyond constitutional limits. They have to admit that ruling class is a real thing, and they can't do that, because many of them are part of that ruling class. Gun control advocates can't talk about this quote because it shifts the debate. It's no longer about assault weapons or public safety. It's about whether we still live under constitutional government or whether we've moved beyond that. Politicians can't talk about this quote because it calls out their entire approach to governance. Your rights are important when they're convenient to us. So everyone ignores it. They focus on the self-defense arguments, the commonly owned language, the airbag comparisons, safe quotes that don't threaten the system. But this quote? This is the one that matters most. Here's what you need to understand. This isn't just about guns. This is about all your rights. If the government can ignore the Second Amendment because it's inconvenient, they can ignore the First Amendment, the Fourth Amendment, the Fifth Amendment. All of them. That's what post-Constitution era means. A world where your rights exist only when those in power decide to respect them. Judge McGlynn saw this. He called it out. And his 168-page ruling is a warning to every American. This is happening. Right now. And unless we pay attention, unless we fight back, we're going to wake up one day in a country that has a constitution on paper but doesn't actually follow it. So here's what I want you to do. Share this video. Not because I want views, though I appreciate that, but because people need to hear this quote. They need to understand what's at stake. Hit that like button. Drop a comment below with your thoughts on this post-Constitution era warning. And subscribe if you haven't already, because I'm going to keep bringing you the information that the mainstream media won't. The fight for constitutional rights isn't just about guns. It's about whether we're going to be a free people governed by law or subjects governed by a ruling class. Judge McGlynn just told you which direction we're heading. The question is, what are you going to do about it? Thanks for watching. Stay informed. Stay free. I'll see you in the next